Would you understand? Take the seats, please. We got to get going.
In that order. Mr. Chairman, before you start, are we going to vote on anything today?
Let's work like that. We have to do a report. We're so far from a real report.
Is there going to be any additional information that we're going to hear today that's going to help me agree to this report more than I already do now?
We're trying to separate the sweet from the chaff, that's all. You know what we're doing. I love to, I wish I could give you the quick, simple one. I wish I had the answer now.
Me too.
Representative, would you please talk to us about what you just discovered in this conversation about what D should actually say?
Okay.
Just so you can note this for the report you have in your hand.
Okay.
It should be adjusted at least to say.
D should say, utilize the false and/or incomplete GAL report by GAL Tracy Benson as testimony in arriving at her decision. Now, looking at the GAL stipulation, which I have here, we can make copies and hand them around. It says under 2 that the issues to be investigated by the GAL are parenting time, semicolon, influence of the companions of either party of the child. Mr. Youssef's companion was not properly looked at. Where Luke should attend school. That issue was never investigated. The school that he was attending was not investigated. The school where he was recommended to attend was not investigated. Number 8 particularly says the individuals to be interviewed by the GAL are as follows: Joshua Youssef, Mr. Youssef's significant other, who was never interviewed, and then a number of other people who were interviewed. Number 11 says
the incompleteness of that is simply that the other was not interviewed?
Correct. Number 11 says the GAL may make home visits in order to meet the child in a comfortable environment. The visits were only made at the mother's home, never at the father's home. I think that's it. And the GAL admitted during the hearing that she had no particular knowledge of why the child should go to the school she had recommended, other than children are resilient.
So do we have a complete list of all the visits and where they took place? Of the GAL?
I don't know when they took place because it was never disclosed to me. She never visited my son at my house. So I know that she met at least twice with my son at the mother's house. But I don't know the dates and times, circumstances. Whether the ex-wife was in the room with the GAL during the interview.
Actually, I'm asking you if there's any reports. Did she do reports? What could we look at, as I'm really asking? What could we look at to ascertain that she never went to your house?
Unfortunately, I can't prove the negative. It just didn't happen.
That's a difficulty we have as well. Representative?
Well, I guess the point with B was that he says she never came to his house. You can't. There's going to be no report of a home visit.
No, I would expect that he would potentially have a report that would show what she did.
I guess the report that I brought during my prior testimony is the very report that I'm complaining about. That was made incompletely and under color of law. So the whole thing is fraught with issues. The thing is as unreliable as an old car.
Mr. Chairman?
Representative.
I'm sure I'm completely out of order here, but I would like to ask, just sort of toss this out, I'd like to ask the opinion of Mr. Youssef. I don't think it's appropriate. I don't necessarily think we have before asked a candidate, a petitioner, about a potential resolution per se. But
you mean a remedy?
A remedy.
We aren't there yet. Do you mind if we wait for that?
I do. Mr. Youssef, because I'm leaving as soon as I make this statement. Mr. Youssef, once a guardian ad litem files a complaint against a parent, do you think that it would be appropriate for the courts to appoint a new guardian ad litem to prevent potential retaliation based on your experience?
Yes, to the extent that a guardian's agreed upon.
Right.
But I believe it's grounds for recusal
Okay.
or de-appointment.
I like that.
We are at E, refusal to admit petitioner's property. I take it on D. I guess my point of D is, do we document anything in terms of the word incomplete? I'm worried about incomplete, meaning we don't.
It's a matter of court record, and I guess it would only be available by obtaining the tapes and CDs. For the purpose of expediency, I'm even willing to strike it, but for as a matter of testimony, I'd like to state that I offered to submit or admit as evidence properly authenticated documents that I authored, that I testified to the authenticity of, that were rejected by Marital Master Geiger. I mean,
Right.
I followed all of the rules of evidence to admit the documents, and yet the Marital Master refused to admit the documents with disregard for the rules of evidence.
Mr. Chairman, might I ask somebody who might know, are the family courts required to actually follow any rules of evidence whatsoever? Yes. I think I'm pretty clear about this. I've made just about every point. No, we're not voting today, you already said.
We're obviously not getting to the end of this thing.
My car, my car was totaled last week. I have to get to the insurance company so that we can go and get the title signed so that I can actually get another car. Because right now, otherwise I can't be here. Do you guys
Stay
want me
tuned
to
for
be
the
here?
final version of this thing.
Stay tuned.
What's that?
Stay tuned.
We're on, recess that thing right for
Oh, can I?
Oh, before we do that, yeah, we'll do that. Yeah, thank you.
I have to leave at 3.
Yeah, I'll take it. All right, I'll find someone to go over there for it. All right, let's see if I can, refusal to admit petitioners properly authenticated exhibits. Would you just do me a favor? Let's go to the, while we're here now today, hit the top points here. Just select them out for me.
Sure.
Let's just do top point stuff.
Okay, this is a very, very important one, is 3F, issued a parenting plan that does not comport with RSA 490D9.
Right.
RSA 490D9 had two versions, one that was in effect before January 1st, 2011, and one that was in effect after January 1st, 2011. The one after January 1st, 2011 required that all marital master recommendations be sworn, and the judges need to sign their signature to approve it, and the signature needed to be accompanied by a sworn oath that the judge had read and determined that the marital master's findings were lawful.
Okay.
And I have in my possession a parenting plan, which is a court order, which was not signed in compliance with RSA 490D9.
Was there a pattern of these, or was it one?
I believe there were two in my case file. I only supplied one to keep the document pile as thin as possible.
Given that we're probably looking for a pattern, you could easily say something might be left accidentally at some point. Would you not agree that possible?
Whether or not it's possible,
It's still outside of.
It's
not the right thing to do.
It's possible, but the problem is that there's no room for error on the part of judicial officers. They need to remedy the error. I moved the court to remedy the error, and they refused in writing.
In writing?
They denied me.
And is that in our documents here?
It is not. I would be happy to provide it to you.
Would you do that?
Absolutely.
Okay.
Because I asked the court to sign this,
We're clear on this.
and they refused it.
You can take care of that. That would be very good.
Okay.
Like that. So get us the next highlights.
Okay.
Do top points. We have so many
Well,
we're going to want to leave.
paragraph 4, A and B follow in line. It's kind of, we're funneling down into the narrow part of the funnel here. 4A and B follow right in line with 3F.
What does that mean? The first one, A.
Okay, wrongly approved a marital master order without proper review or oversight. We now have an order that's unsigned in comportment with RSA 490D9.
That's directly what that refers to. Okay.
Exactly.
Okay. All right. Okay.
And that was just kind of clarified, maybe redundantly, in paragraph B, 4B, so we can kind of
Oh, so we put those two together.
concatenate those.
Good.
Paragraph 5. Actually, this is a pattern, now that you mention it. This is a serious pattern. 5A, denying petitioner due process of law by declining to issue orders on petitioner's motion for reconsideration in accordance with 490D9 again. Marital Master Leonard Green issued an order, which is in your packet. I believe it's in there, and it has his name. There's no judge signature at all. It's just the Marital Master's signature. Marital Master playing God with his pen with no judge signature.
And can you give us an example in front of us where we see a different pattern with it's what it's supposed to look like?
It's supposed to look like...
No, is there an example in which we can see what it's
Yes.
supposed to look like?
Document number 11 is an example of a properly signed order under 490D9. And when I say document number, I mean my hand numbering system in the upper right-hand corner.
Okay.
If you look at document 11, the final page, bottom of the page says number 4 on it. You'll see.
Where is this? Toward the end of this? Or?
Yeah, it should be very near the end.
I don't see any 11s.
Oh.
I'm not there yet. Sorry.
And there are 4 pages to 11.
Sure, it says 11 on it.
Yeah, far upper right-hand corner, it should say order on motion hearing, State of New Hampshire judicial
It
branch.
doesn't say 11 on it.
Is there a page number at the bottom of the
Oh,
page?
I apologize. Mine says 11. I thought I just
What does it look
photocopied
like?
them.
So is,
You see what it
give
looks
us
like?
some direction.
No idea. You're gonna have to help us here.
It's
Okay.
this one,
The state of, oh, it's the next page, right? After
next
10?
page.
Next page
Right
after
after
10.
what?
It has number, page number 272 in the lower left-hand corner.
Lower
Thank
right.
you.
Yes, you're right.
Lower right-hand
That's
corner.
right.
And how
So
many
that's
pages
number
later?
11.
And go on to the 4th page.
Yeah.
You'll see a handwritten date, 6/15/11.
No. We don't have that.
I thought you said 270.
Order on motion
So
hearing.
this is the one that says 270.
Was it 270?
Oh, we do have
Yeah, 272.
No, we don't.
I have 240.
We're missing a page or two there.
Two.
No,
This.
I'm writing it down.
Mike,
Oh my goodness, and I'll give you that.
this.
For you to take as an example.
Whole package. Representative Minister Youssef, it's 272 at the bottom of the page.
It's the 4th page.
See?
Michael, you have 242? It's 4 pages before that.
270.
272 is 4 before
I will
that.
make copies of this.
Well, where's the fourth page? We don't have it.
This is the fourth page.
We don't have
I
it.
know you don't. I'm going to go make copies.
Oh, okay, thank you.
Representative, don't bother. Would you not bother?
You don't bother? Okay, you guys,
Just
Okay.
pass it around. Just sort of pass it around. Just
so,
put a mark on it.
may
or
I,
something.
you have?
You can have it. I have it.
So I will give this to Clark.
No, send it to the viewers.
Okay, good.
Okay.
I have almost 50.
Let's move along. Let's move along.
And then here's here's the document that was not, here's one document that was not properly authenticated, or signed, and here's another one. This is a separate
What it
order.
sign, what it looks like and pass it.
Okay.
There's no judge signature at all on that.
Dan, just
That's
show
a
me
marital
and pass it around. The ones that are not properly signed.
Okay, this has,
So Youssef, on
this
page
has
10,
the
right
judge.
to the end of
This has
page,
nobody.
a lot of the page, a lot of signatures there.
Can I come forward and see what we're looking at?
Supposed to have a judge too?
Yes.
Doesn't have a line for a judge, why
That
not?
is improperly signed.
You know, there's a line for everybody here. Is it supposed to have a judge?
Sworn by the The law says that there needs to be an oath.
It should look like this.
No, that's my certification. This is improperly signed.
There's nothing at all.
Is that moving around? Where's the properly signed?
in no time.
It was here. Send it this way. Send it this way. This way.
Can I just say that he's going above and beyond here?
No, he's not. No, he's not. We have to do that.
No, this is particularly what is required.
We have to know what we know.
This is required marital master signature, then the oath, then the judge's signature. This here is marital master recommendation, no oath, judge's signature. So now this, it could be a judge running one, could be, theoretically, if he has no oath, he has no consequence. This here is a marital master signature with no judge, oath, or signature. That's
Send these 3 pages together.
And pass them in order. Good, good, bad, bad.
Everybody get that? Good, bad, bad. All right, send it. Let's go. Let's get out of here. Let's get this going. Representative, do we have order in the court, so to speak? We have order in the room. So now we're going to Kelly.
yes. And then ultimately, Judge Kelly.
Can we have the conversation, Tom, please? Can we have the conversation, Dan, please?
And at the top of the pyramid is Judge Kelly, who is supposed to see to it that his courts
We don't
are
need the background.
operating properly, and
Provide
they're
adequate
not.
oversight and supervision of marital masters and judges in the county court division. Did you make a complaint? What are we talking about? Failed?
Yes, I did make a complaint to Judge
Do
Kelly.
we have a copy of the complaint?
Yes, you do. It's in
That's in
it's
our
in my
file.
prior testimony. It's not in this bundle.
Okay. Do you have it there? Would you look at it? So you made a complaint, which you expressly pointed out the errors of law and whatever?
Absolutely. 7 pages long.
7 pages? Okay, so we're looking for 7 pages. Failed to protect the constitutional rights of petitioners on this specific. Is this the last thing in the document we have in front of us?
Yes.
Ladies, we don't have it.
Oh, I thought you meant, is this the last item in my complaint?
No, I said, do we have a copy of the letter you sent?
I don't believe so, unless it's... That's it, that's it. I guess I did include it. My apologies.
Oh, I'm glad you did.
I am too.
All right.
You're Judge Kelly, I'm writing it,
We're not going to read the letter.
whatever.
Okay, so you made a request to Kelly, made these points to Kelly, and his response is somewhere in here as well.
Response is not in there. It's in my prior, that I can tell you with certainty is not in there, but I did include his responses at the last petitioner hearing.
Find his response. All right, and,
He said I can't get involved, basically.
yeah, that's what he says. And the same point could be, it's just the constitutional rights were referred to in this,
Yes.
and,
In State versus Robert H., rights to parent one child have risen to the level of fundamental human right and liberty. So when a liberty interest is compromised like this, it falls ultimately on Judge Kelly's law.
and so the third point is that in the aftermath, he permitted his judges and marital masters to effectuate permanent damage by alienation, essentially.
Yes.
Okay. And so in the area of the remedy part, the course contracts you're asking about, the limiting course contracts, tell us, that's come up just obviously earlier. By the way, Mr. Hans, this is definitely not going to be your day. I think you took it already, part of this previous discussion. I apologize to you and the sponsor, it's the way it goes some days. And I will not be able to go to a time certain. I'll have to reschedule. I don't know what it will be yet, but my guess it will be the 19th of July. Or maybe the next Tuesday. Representative, I'm sorry, Mr. So the coerced contracts refers to the GAL's.
It involves, a coerced contract is something that I've seen repeatedly in my own case and other people's cases.
Right.
And it involves a court mandating that an individual, a litigant, engage in a contractual relationship that involves an offer, an acceptance, and consideration be paid in both directions, whether it be services for money, money for services, with a private party. And I object to, in 201 U.S. 43, a U.S. Supreme Court case called Hale versus Henkel, the U.S. Supreme Court says that an individual's power to contract is unlimited. And so that means nobody can abrogate one's unlimited right to contract, whether it be enter into a contract or to not enter into a contract. And so this is a big, big problem in the family division, is that they force you to get involved in relationships with therapists, with guardians ad litem. They wrongly and incorrectly require attorney's fees to be paid directly from one litigant to the other opposing party's lawyer. against a court case, a Supreme Court case called Town of Nottingham versus Cedar Waters, a very important case where sanctions and attorney's fees as sanctions are designed for the benefit of the complainant, not the complainant's attorney. And what the problem that presents, in closing, is that when you start coercing a litigant to pay the opposing counsel directly, you have just created an extreme conflict of interest. Extreme.
I think we understand. Is there any question on this point? The second point, the law of the state should be amended to make clear there is a presumption that fit parents will act in the best interest of their children. I think we already have that, don't we?
That's the law of the land. In the U.S. Supreme Court, the New Hampshire Supreme Court has ruled that is to be the case in a case called In Re Guardianship of Rena D.
Change?
I think it should be adopted as a statute, into the statute, so that it is not, there is no discretion that can be applied.
Now, a court
No.
rule? What is
It's
it
a Supreme Court decision.
Opinion. It's an opinion.
now? Okay, so you're asking me to destatutize, okay. Okay, we don't, any questions on that point? The law of the land state should be amended to provide greater supervision and accountability for what done. And that Mayor Mess's judges in the circuit court family division provide the same, with the elimination of both the marital master and the what?
Guardian life.
And I know the marital master program has theoretically come to an end, but in practice it hasn't. But I question when a litigant raises the due process claim that his rights have been denied by being heard by a different officer than the one that signs and makes the decisions. You have a link in the chain. You don't have direct access to the authority. And you're essentially doing business with an at-will employee of the judiciary, which is a marital master. And I have raised the issue that I do not want a marital master involved because A, is a training issue, B, there's a they kind of have
Can we shorten this by saying
Sure.
that we know they're going away? They're being eliminated.
problem solved.
The guardian ad litem is not going to go away by recommendation of this committee or anybody else.
Yeah, no, I hear you.
It's a long history that will maintain because of need. It doesn't mean it shouldn't be managed.
Yeah, I believe there needs to be
Problems.
serious management put in place, and
Yeah.
there's some teeth needs to be put in the consequences to their.
So let's say there are others that here that you actually that do apply further. So introduce legislation for the courts to deviate from equal parenting time is only in cases where there is clear and convincing evidence of abuse and neglect by one or both parents. Representatives of
I'd like to speak to that. There are problems with that because there are other reasons to deviate from equal time. One parent travels, the child is an infant. There are a lot of reasons to deviate from that.
Or could you say, or by agreement or something like that? Or by
Well, what you should do, which we have been unable to do for my tenure on children and family law, is to make a presumption of equal parenting time, from which you have to deviate.
And
have that.
I think a way to.
Don't we have to?
No.
There may be some wording, maybe a rebuttable presumption that's subsumed in the clear and convincing evidence standard, or something along those lines.
We've already got that in some recommendations that the Republican Party is bringing forward for next year.
Okay.
Introducing legislation adopting strict rules of evidence for the family division.
Yep.
We've got that already
In the works.
Yeah. Doesn't mean we can't recommend it.
Yeah.
But we reinforce the need for that.
Enforcing it, yeah.
Yes.
And in both points, in both cases.
Yes.
And 6, examine whether impeachment proceedings should be initiated to remove Judge Kelly, Gordon, and Shepley. Is there a question about that?
I guess a style and form issue. It would be a recommendation to introduce a resolution to investigate.
Yeah.
Having done this.
Yeah. Representative Party.
Pointing over we're down to 10, so we compare the form.
Yeah.
Can I make a motion to accept?
Yes.
No, I'm not going to accept the motion. We're going to have to rewrite this. It's too complicated.
Yeah.
You write it.
No, it's got to be rewritten.
It's got to be rewritten. There's all kinds of stuff in here that we've stopped over.
It'll be
and
written in
won't apply.
the correct form.
Let's just come back.
I mean, we can act on.
Don't get upset. It's life. Fast enough. What?
I mean, I think
Yeah. Yeah.
I think there's a question on the point that if it does accurately summarize what Mr. Youssef case is, whether everyone's accept that this case is valid or not, is probably not thinking again, yes or no. But this does, I mean, this is a good summary of Mr. Youssef's voluminous documentation.
Can we get to point 7? No, the committee actually needs Representative Avard. The committee actually needs more time to talk among ourselves further. We do need more time to finish this out. So what I'm proposing is a revisitation, just a consolidation and all that sort of stuff, and a last discussion among ourselves and make sure we're on the same page. And then the motion, if you can see that. And point 7, introduce legislation to require all judges, marital masters, guardians ad litem, hearing officers, and clerks of court to disassociate themselves from the Bar Association.
There's an inherent conflict of interest.
Oh yeah, I think we all agree with that. We've actually tried to eliminate the bar itself. How close do we get this year?
Not close enough.
Still has a recommendation, just for the record, I think it's still a good suggestion.
Yeah, let's
What I would rephrase that to that the legislature should investigate the conflicts of interest that arise in such cases from the bar. You know, go for success.
So an investigation will look into the significant, what happens by
Is there a way to untangle the conflict of interest?
Is there an inherent conflict of
Did
interest?
somebody identify the conflict?
They're all in the same club. They're all in the same private club.
If I could speak very quickly to
You know
that,
what?
when a judge or a marital master, according to Judicial Canon 3D2, when a judicial officer has reason to believe that an officer of the court has violated a rule of court, a principle of ethics, it is the duty of the judge or marital master to report those findings to the judicial conduct or the professional conduct committee. And when they're part of the same organization that has they have financial ties to that organization, that is precisely where the conflict of interest exists.
So I think we're clear on where everybody's going. Is there further discussion of recommendations? Representative
I was wondering if we could introduce, I would like to have a whole new constitutional court where somebody who wants to not go to go to a constitutional court for family or whatever else comes up.
Actually, I had a phone conversation this morning with 2 or 3 people. Among the, you may have been mailed, you may have not been mailed by me.
I sent you the email back.
That's right, you responded. I
Yeah.
got a response back from a lot of these people, and I've asked them, and one of the points that came back was we need to consider whether or not we should have courts of equity when people lose these kinds of rights. Or when, and it used to be the Superior Court, you have all your, as I understand it, you have all your constitutional rights and so on. So this begins to be an interesting issue and question that's been brought to us. But yeah, if you want to throw that into the question.
The predominant issue with the court of equity is, you don't want the child to testify, and that's the argument against strict rules of evidence. But there's a way around that. It's called the tender years hearsay doctrine. And there's a way around that and still keep strict rules of evidence.
So any further discussions? So with apologies to Representative Avard, it's so much work, we can't just close the door. You know what we've been doing. We write reports, we redraft them, and revisit. So you will be being apprised of an actual exact date for the work session, potentially today. And thank you very much for your attendance. And enjoy your holiday week.